Hello and welcome to the final episode in our Expert Witness series. I'm Sara Grewar, I'm a solicitor and claims team lead in Ireland here in Medical Protection and your host for today. In this episode we're going to be talking to two guests, Rebecca Ryan and Nick Deal. A wee bit of background about both of them. Rebecca Ryan is a partner in Matheson and is head of their healthcare group. She's a recognised leader in her field, specialising in professional indemnity and product liability claims. Rebecca acts for a number of indemnity bodies, including Medical Protection, where she represents her members across a range of matters, including claims, inquests, disciplinary and criminal matters. Rebecca acts for internationally focused companies doing business in and from Ireland and provides her specialist knowledge in the healthcare sectors. She's an accomplished advocate with a keen interest in mediation and alternative dispute resolution, having previously qualified as a solicitor in England and Wales. Nick is head of expert witness training at Bond Salon, who are one of the UK's leading legal training and information companies. They provide training and information on legal knowledge, procedure, evidence and skills with innovative, relevant and experiential courses designed to improve best practice and performance. Nick himself is a qualified barrister, having called to the bar in 1989. He held a common law practice and represented clients before all levels of courts in the UK. Nick trains professionals across all disciplines to help ensure they can fulfil the role of expert witness, and he's also lead trainer for the Cardiff University Bond Salon Expert Witness Certificate, which is widely regarded as a gold standard within the expert witness industry. So I'm really delighted to have you both with us. Thank you so much for joining us today. In the last episode, we heard from one of our MLC colleagues, Dr. Rebecca Whittaker, and she actually acts as an expert witness at the moment. And I'm really hoping that her enthusiasm for that type of work will have inspired some of our members to want to become expert witnesses. So in this episode, we're going to discuss a little bit more of the practicalities of what the work entails and how our members can take the next step to becoming expert witnesses. So Rebecca, if I may, I'm going to start with you. As I've said, you represent our members and across a various range of matters. Can I just ask you to elaborate that? When is it you involve expert witnesses across these various matters that I've talked about?
Thank you, Sarah. So, as you said, we work as a team defending MPS members in a full range of types of claims and complaints, be it a civil claim, a regulatory investigation or complaint, an inquest, or sometimes a criminal investigation. So for us as lawyers, the experts are really vitally important for us to kind of unpick the facts of the case, identify issues in the case, look at defensibility or look at strategies for resolution of cases. And the main reason that they're so important for us is because they very much set the standard in those proceedings, which will ultimately be determined either by a judge or a committee. And from the doctor's perspective and from the members' perspective, the experts are invaluable, really, because they're judged and tested by their peers. And they want to hear from their colleagues, you know, what are the issues, where care may have fallen down, where there may be systems errors, but they also want to feel supported by their colleagues, even if there's a negative opinion given in a case. So it's really important from their perspective to feel that they're being heard by colleagues and not lawyers determining issues in the case. So I suppose the support as well as the legal aspect is where we consider them to be absolutely vital in all the range of cases that we're involved in.
Brilliant. And I think that's, as you said, it's really interesting because I think when I've been dealing with members, what they're looking for is somebody to give them a really accurate view, not just to say what they want them to hear. And I think going back to that, something I talked about with my previous guest is the fact that the key duty of an expert is to the court. And I'm not sure that that's always particularly widely understood by anybody involved in litigation. And Nick, perhaps if I can turn to you, obviously, there's no requirement to have particular qualifications to act as an expert witness. The fact is, you know, if you are a consultant with good experience, then effectively you will be an expert. But I think it's really important to get some background into understanding before you start embarking in this work. And that's, I understand, where you and your company come in. Perhaps you can tell us a little bit about the sorts of background and experience you can give clinicians who are interested in taking on this type of work.
Yeah, sure. I mean, absolutely right. So from their own practices and their own experience, they have the expertise. So they got the knowledge, the basis, the understanding, and everything else that's needed. But then to be an expert witness, you need the other half of the package, which is to understand what the court is looking for from the expert. So it's not just having the expertise, vital though that is, it's knowing how to deploy that for the court. And the crucial thing here is this concept, as you were saying, of the duty to the court. And most experts in their practices are unaware of this, and why would they be? Because they've not stepped into that work before. And this is so crucial because the judges, certainly over the last few years, have become increasingly energetic about policing. Not only does the expert have the knowledge, but do they understand their role? And it's crucial that the expert understands what their role is. And so that's really the foundation of what Von Solon is doing, to help experts understand what this duty is to the court, what it means, and then how it plays out in every aspect of their work. So we run training on writing reports, which is the sort of the obvious immediate level for experts. But then we also look at all of the other aspects of an expert witness's work, which could be dealing with questions from their own instructing party, asking if they can amend or alter their report in some way, or correct it. What are the boundaries of all of that?
Yeah.
Dealing with written questions from the other side, which they might have to look into. Dealing with discussions with the other expert, what's involved there? How does the duty play out in that environment? And then, of course, finally going to court as well. The majority of experts very rarely get through to court. I mean, Rebecca will know this far better than I do. I've long since left practice, but for an expert, actually getting into court is quite rare. All the more essential to know how to conduct yourself in the courtroom and how this duty to the court plays out directly in the courtroom environment as well. And that's the report writing and the delivering evidence in court are two of our key course areas, and we cover all of the rest as well.
Brilliant. Yeah, and certainly when I was talking to my guest in the last episode, she was talking very much about report writing, and that if you enjoy that side of things, then actually expert witness work is a great kind of sphere to get into. And interestingly, as you say, most of her work, she says, is about the report writing. A little bit of it is then to do with conferences and consulting with legal teams, and a much smaller part is actually being in the courtroom. So it's that kind of forensic analysis of the case and being able to be articulate in how you present it, and present it in a really clear format. Now, certainly, as Rebecca and I will know, from our side of things, we'll be the solicitors instructing experts, and there's a real onus. You should be expecting the solicitor who's instructing you to give you a really clear scope of what it is you're asking them to look at, and what the duties are, or what the test is that you're looking at. Because obviously, Nick, I know you're UK based. Rebecca and I, between us, have experience in Ireland as well as some of the UK jurisdictions. The legal tests are slightly different. You know, in Scotland we talk about Hunter Hanley, and in England, Northern Ireland, we talk about Bolam. In Ireland, we talk about the Dunn principles. All slight nuanced differently, but by and large a very similar test. But the solicitor sending you the instruction will very much set out what test it is you're being asked to look at, and really the scope of what it is they want you to cover. And I suppose, if in doubt, and if the solicitor letter isn't clear enough, you'd be saying to them, you really need to give me clear instructions of what it is you want from me. But I suppose, as I say, although the tests are slightly differently, a lot of these skills, like report writing and like courtroom skills, they're applicable pretty much regardless of which court you'd be appearing in. Is that your take on it as well, Nick?
Yeah, it is. I mean, we do the Cardiff University training that you were talking about earlier on, which is obviously directed for English and Welsh legal system. We've also recently launched the Aberdeen University certificate as well, covering the Scottish legal system. However, for the report writing and the evidence giving courses, we're actually putting people in the same room, because there are differences, of course, in what the courts are called, in the how to address the judge, which often undoes every witness that I've come across, and confuses a few barristers as well. So there are those sort of practical differences, but the fundamental skills and the principles, yes, I think apply across the board. And you can't go wrong if you're applying this concept of, as an expert witness, I'm there to help the court. I'm not there to argue the case or to fight the case or to be an advocate. I'm purely and simply there to help the court to reach a sound decision. I think all of the jurisdictions would be happy and confident in a witness who's presenting themselves in that way.
Exactly. And I think that's a good point. And Rebecca, something that comes up in our conversations with members at certain times is the fact that, I might be dealing with a case in Scotland, but an expert report comes in from the other side from an expert based in, say, England, or likewise, I'll be dealing with a case in Ireland and an expert report will come in from an expert based in Scotland. And sometimes you'll question, is this expert well placed? And I suppose that's something I wanted to kind of just tease out with you. Certainly from my point of view, there'll be sometimes it's entirely fine and no issues at all with the fact that it's a different coming from a different country. But perhaps you could give me some commentary or thoughts on where and when that doesn't work so well.
Yeah, and I'd echo everything that yourself and Nick have said in relation to whether somebody can be an expert witness is really down to their clinical expertise and experience. Can I provide a clinical opinion in this case? And as Nick says, they're very much not an advocate for any party. Their overriding obligation is to the court and not to the party paying their invoice, which can sometimes be lost. But I think really as to whether you can comment on another jurisdiction depends upon the type of report that you're being asked to produce. So, for example, if you're being asked to give a breach opinion, so you're commenting upon a practitioner's management, then there can be difficulties with that, because if we have an Irish-based GP and the opposing party has got a UK expert or a Scottish expert GP, that GP may not know about the systems, processes, resources available, the guidelines of the local jurisdiction. So that in itself can cause real difficulties. And I suppose if the opinion is fundamentally unsound because they don't know the systems or the processes, the guidelines, it can be easily unpicked by a barrister under cross-examination or by a judge. And so it's easily challenged. I suppose there are other areas, for example, causation. So when we say causation, we go, okay, there's been a breach or there's an issue with management. What flows from that? That's what causation is, essentially. That doesn't necessarily matter, because I think if you're looking at what flows, what injury flows from that act or omission, that potentially could be a neurologist from England commenting upon an injury to a patient in Ireland. Further again with condition and prognosis. So if you're assessing a patient to assess their injury, again, I don't think there's a difficulty in that. So it very much depends, I think, upon the purposes and the report you're being asked to produce. And again, if you're unsure, as we've all said, it's just ask the question, go back to the solicitor and make sure it's very clear what you're being asked to do.
Yeah, no, I think that's well placed, and it makes me think of another point that is worth highlighting as well. Is I suppose when you're getting it, if you're approached to give an opinion, A, think about, are you best placed? And B, also think about your particular field of specialism, because I think this can sometimes be an issue. You might well get a solicitor thinking, looking up a directory, finding, oh, right, you're an orthopaedic surgeon. Great. I'll contact you for this hip replacement injury claim. And then, you might be well pleased to talk about it. But if actually the 90% of your workload and 90% of your patients relate to foot surgery cases, is that going to be a difficulty? Is that something you've seen, Rebecca? Is that something that you can comment on as well?
Yeah, absolutely. And there's, I think that's definitely an issue where you're being approached by solicitors, and oncology is another area where they go, okay, well, this is a delayed diagnosis in cancer case. Let's brief an oncologist. But that oncologist is a breast specialist rather than a cervical cancer specialist. So it's very much understanding what the issues are, what you're being asked to do, and whether that's within your clinical area of expertise. I suppose the other point I wanted to mention as well, and Nick touched upon this, is this idea of preparing draft reports, because there are differences in different jurisdictions as to whether those draft reports are disclosable. So again, engaging with your solicitor about, do you have all of the information? Do you have all of the records? Do you understand all of the issues? And having that conversation with them before you put pen to paper to make sure you've understood all of the issues. And I think the other potential issue around that, Sarah, is where You may have approached a particular specialty, and actually there's 3 or 4 defendants in a set of proceedings, or there's another issue for a doctor that's not been named, and you start, identifying issues for other people that are not within the case. So it's very much stick to what you've been asked to do. Of course, if there are other issues, pick up the phone and have that conversation. But it's limiting your opinion to the letter of instruction, I suppose.
Yeah. And I suppose as solicitors practicing this area, we see these kind of common pitfalls. And Nick, again, like I said, although you don't need particular qualifications, I suppose that's why doing some sort of course, the likes that your company offers, helps, because they're quite easy things to avoid in many ways, but it's just, I suppose, having somebody made aware of them and flag them up to you before you embark on this type of work. Is that your take on it?
We get a lot of people coming onto our courses, the whole range actually, in terms of some who've never done any expert witness work before. Yeah. That's probably the majority, but we get quite a few coming on who've been acting as experts for 5, 10 more. Sometimes I had somebody join who had about 30 years experience and then decided he'd come and get some training, which was quite an interesting thing. Mercifully, he'd been going fine all the way through, but yeah, I mean, an expert becoming an expert witness, none of us knows what we don't know, and therefore it's entering an unknown area. And what we do is to make that unknown area more familiar, accessible, and yes, all those common pitfalls. We've talked about the duty to the court. We've talked about the tension that can exist between an instructing party and the expert, and the expert's duty to the court. Now that can be an unspoken tension, because quite naturally and almost subconsciously, the inclination of the expert could be, well, you're paying me, I'm part of your team, without any undue influence by the lawyer at all. And yet, of course, the expert isn't part of their team, and they just need to be really crystal clear in their own minds. This is my opinion. My opinion is just on the evidence, and in that sense, that the test they need to give themselves is, would I say the same thing if the other party in the case had given me the same instructions? And it just drives them down this purely evidence-based approach, and just keep it clear, keep it simple. Here's the evidence. What's my opinion? And if you build from that level of simplicity, I think everything else falls into place.
Yeah, and I think you're right. I think certainly Rebecca and I have been in many, many meetings together with experts and members, and as you say, it doesn't actually help the member of the clinician, doesn't actually appreciate at the end of the day if somebody's trying too hard or really, really not following the evidence to try and help them out, because actually what's a better help is to just get a very clear understanding. They'd much rather know from a written report and from a conversation with an expert at a conference with just Rebecca and I than, at the door of the court or indeed in the courtroom. So yeah, I think it's really important if people are embarking on this work to just have that. It's, as you say, it's not about I'm instructing you, so I want you to just say a certain thing. I'm instructing you and I want to know your genuine, honest opinion, and whether you would give that, as you say, to me or to any other party in the case who asked of it. No, that's really interesting. I think we're all on the same page in that sense. So, like I say, I think what I was hoping to get across to our members is that there are some pitfalls, but with a bit of training, these are actually easily avoided. And once you're kind of, I suppose, up and running as an expert witness, certainly from my last guest, Rebecca, she really enjoys the work. And Rebecca, you've got a close relationship with lots of the experts. There's a lot that you would instruct regularly. You can't speak for them, but is it your sense that they enjoy the work? I mean, certainly they keep doing the work, and it's obviously work that's entirely voluntary from that sense. And is that your sense when you're dealing with them?
Yeah, I mean, I think obviously they're very experienced clinicians. Some of them are very experienced at providing reports. Some of them have only just started providing reports and learning as they go. But for the majority of them, it's really intellectually challenging to go through all of the expert evidence to identify issues in the case. We've had some really complex cases where we've had to do, deep dives into literature and resources and just trying to, as I say, unpick all of the issues in the case. I think they all really love that challenge. They also really like engaging with the legal team and having that kind of team approach to supporting members through what's a very difficult process for them. And then the challenge of giving evidence, and that can be a somewhat daunting experience. But I think, as Nick says, you're there to help the court. You're there to give them your opinion and to take them through the case. And I suppose if you approach it in that way, it is a very rewarding job to do. And in my experience, they all really enjoy doing it. It's a great part of the job. And as I said when I started out, I think from the members' perspective, it's really, really invaluable, and they do feel supported by their colleagues, even where it's negative, because they're being given the information from a good place. And as you said, Sarah, it's better for us to understand that early on in a case, either in the report or in a conference, rather than at the door of the court, where you are going to be challenged and tested by the opposing legal team.
Yeah, brilliant. Well, I really appreciated talking to you both today. I'm also really pleased to say to people that both Rebecca and Nick are going to be part of our webinar, which is going out live on the 24th of May. And in that, we're going to be able to talk about these issues in a bit more detail. There'll also be a Q&A session. So if there's any questions that I haven't asked either of them that you're wishing I had, there'll be the opportunity to put that to them then. So like I say, I'd just like to thank you both. And with that, we're going to come to the end of our final episode of the Expert Witness series. Like I say, thank you to both of you today. Really appreciate your contributions, and indeed the other guests who've contributed to the series. I really hope that the topics that we've covered have given you an insight into the role of an expert witness and the opportunities that are available to you if you're interested in pursuing this type of work. So like I say, just a final reminder that we have the expert witness webinars coming up on the 10th and the 24th of May. You can use the links in the podcast description to register for those, and I'd be delighted if some of you could join us then. So with that, thank you again for listening and or watching. I've been your host, Sara Grewar, and it's been lovely to speak to you. Thank you very much.